you debit in it, the higher will be the success and happiness credited to it. To summarize, don't stress, do your best and forget the rest. Telling this, I hand over the session to sir. आज देखते हैं कि सर हमारे लिए कितने मैजिक बॉक्सेस लेके आए हैं और उन मैजिक बॉक्स में से कौन सा खजाना निकलेगा। मेरे प्यारे साथियों, जरा सोचिए, अगर यही क्वेश्चंस आपके एग्जाम में आएंगे तो ये आपको मैजिक बॉक्स नहीं बट लेकिन जैकपॉट कहलाएगा। Over to you, sir.
Good morning, ma'am.
Good morning,
my
sir.
dear students. Well, magic box या jackpot, पता नहीं, वो वक्त बताएगा. But yes, our intention is to make sure that your life becomes easy. Our intention is to make sure that you receive the best. Our intention is to make sure that you are having the best so that you are well prepared for the examination. So, dear friends, yesterday, amazing session, 1.5 hours in the night. I was so much thrilled कि यार इतने प्यारे बच्चे, इतने सारे डाउट, कितना कमिटमेंट है. Hats off to you all. Superb. I enjoyed the session. Hope you would have also enjoyed it. But the students, those who have missed out, probably due to genuine reason, probably they might have not have doubt, all those things. Please make sure that you still do your homework, complete the task, and still you have doubt. We are there to support you. With this note, today's journey, we will be starting with Sale of Goods Act. A beautiful act. Again, 6 to 8 marks is what expected. So a lot of pitaras will not be there. But yes, all those questions which we as a teacher believe could be tested is what will be there in the pitaras. So how many of you are willing to start? Sir, yes sir, शुरू करते हैं और आज इसको जबरदस्ती नहीं जबरदस्त पढ़ते हैं. पढ़ेंगे जबरदस्त. Let's start, sir. Yes, sir. क्या यार सुबह सुबह. How is the जोश? पता नहीं सर, जोश का तो पता नहीं. हम तो रेडी है. Very high, sir. On the peak, sir. Very good. With that, let's start. स्क्रीन दिखाई दे रहा है? क्लियर है? Great. So my dear friends, small topics, now nothing big is left. I think we have crossed a bridge of 60% of your syllabus. Balance 40% in 4 different acts. So अगर वो ही करना है तो टेंशन कहाँ है. फटाफट हो जाएगा. नेक्स्ट 5 दिन में लॉ खत्म. 5-6 दिन में. I think I have another 5-6 days of class left and we have 4 units to go. So टकाटक फटाफट सब कुछ खत्म करते हैं. Are you there? Okay, how many of you believe Sale of Goods Act is relatively easy compared to Contract Act? Me, I believe it's easy, way more easy. Yes, sir, it's quite easy. Okay, sir, kind of easy, sir. Super. Why do you think sale is comparatively easy than contract? Can anybody give me a genuine reason? Don't say such छोटू सा act है. Ronson, very good. Able to see your chat for the first time in last 4-5 days. Sir, we actually get engaged in sale. Very good. शादी कर ले बेटा. Don't know, sir, but really easy, sir, because it will happen in our daily life, sir. Okay. A part of concept we have covered in Indian Contract Act. कौन थी भाई वो? कौन थी था? Shrisha. Okay. Some things are related to previous chapter. Sahana. Very good. सर बच्चे हैं ना सर कॉन्ट्रैक्ट के. वेरी गुड. मम्मी पापा को याद किया इसलिए बच्चे तो याद आ ही जाते हैं सर. वेरी गुड. माय डियर फ्रेंड्स, Let me tell you why it is easy, and at the same time हर एक easy नहीं होता है. There are certain things which are like easy but don't know. एग्जाम की टाइम ब्लैंक हो जाते हैं because we start relating things too much. हम सेल को सेल की नजर से नहीं, कॉन्ट्रैक्ट एक्ट की नजर से देखना शुरू कर देते हैं और वहां पे कंफ्यूजन शुरू हो जाता है. How many of you agree? If you have written some of the mock test, I agree sir, पक्का sir. अरे बेटा तुम्हारी प्रॉब्लम मुझे पता है. Good. So let's do one thing. Let's not waste much of our time. Today's agenda is टक 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 यूनिट 1 यूनिट 2 खत्म करना है, तभी जाके हम लोग सिलेबस खत्म कर पाएंगे. So are you with me? Let's start. Yes. So इसमें टॉपिक के पहला लाइन ही गलत है. How many of you have read the first sentence? And what is the mistake? सर अभी जम्मू एंड कश्मीर में भी applicable है, except the state of Jammu and Kashmir is ruled out. Please do not go with this note. It is also applicable to Jammu and Kashmir. Kindly make a note of it. Second, कब आया था enforceability? 1st July 1930. Originally, the law related to sale was provided in dash section. Section number कौन से थे? The basic rule of sale of goods act, section number 76 to 123 and chapter 7 V11 Roman letter 7. Yes or no? My dear friends, very important to remember and imply is the sale of goods act deals only and only with movable goods. They do not deal with mortgage, pledge, services, movable properties. Am I clear? Superb. Let's move on. Tack. So, who are the parties to the Sale of Goods Act? Generally, two parties, buyer and seller. Who is a buyer? Who buys and agrees to buy. Who sells and agrees to sell. Is it right? How many of you believe the statement I made is right? Sunidhi say, yes, sir, you are right. Anup says, or sir. Padmini say, yes, sir, you are right. Yes, sir, right, sir. Bhavna says, no, sir. Vaishnavi says, no, sir. Shrisha says, right, no, sir. अरे बेटा ध्यान से सुनो, मैंने and बोला था और नहीं. A person who buys or agrees to buy. The person who sells or agrees to sell and नहीं आएगा बेटा. देखो छोटी छोटी बातें and or makes a lot of difference. Shit, मैंने क्या गलती कर दी? होता है बेटा, बड़े देशों में छोटी बातें होती रहती है. Correct? Don't feel that you are wrong. At least you have attempted. That is good. Can we start? Great. So, how many of you remember the definition of contract of sale? Contract of sale. टक. किस को याद है? 1, 2, 3, 4, 5. That's all. Out of 200 odd students, only 5-6 students remember. बेटा important definition है. एग्जाम में डायरेक्टली पूछ सकते हैं. Define contract of sale. Section 4, subsection 1. Section 4, subsection 1 of Sale of Goods Act defines contract of sale as a contract of sale is a contract. सबसे बड़ा word क्या बोला है? It is a contract. अभी कॉन्ट्रैक्ट को याद कहां से करेंगे? इंडियन कॉन्ट्रैक्ट एक्ट के हिसाब से. और कॉन्ट्रैक्ट इज डिफाइंड अंडर सेक्शन विच ऑफ इंडियन कॉन्ट्रैक्ट एक्ट? 2H. क्या बोलता है 2H? Every agreement which can be enforced in the court of law becomes a contract. Yes or no? So contract of sale is also a contract which is defined as per Indian Contract Act 1872. Do not write this statement in the examination. You have to just mention a contract of sale is a contract whereby the seller transfers or agrees to transfer. अभी देखो डेफिनेशन में ही आ गया है और, मतलब दोनों एक साथ नहीं कर सकता है, या तो ट्रांसफर करेगा या अग्री करेगा ट्रांसफर करने के लिए. एंड नहीं आया है और आया है. whereby the seller transfers or agrees to transfer. क्या ट्रांसफर करेगा? Ownership of the goods, which is technically called as property in the goods. किसको ट्रांसफर करेगा? Whom will he transfer? Buyer. Very good. और क्या वो फ्री में कर सकता है? For transferring the ownership of the goods, what he will receive? Price. The consideration in form of price. Yes or no? याद है डेफिनेशन कितना सिंपल है? देखो कॉन्ट्रैक्ट को उन्होंने बोला है, नेक्स्ट बोला है क्या? कंसिडरेशन को बोला है अकॉर्डिंग टू सेक्शन 2H एंड 2D. दोनों चीजें एक ही डेफिनेशन में आई है 4 सबसेक्शन 1 ऑफ सेल ऑफ गुड्स एक्ट. सो मम्मी पापा याद रखना बेटा कॉन्ट्रैक्ट एक्ट को. यस, कम ऑन एवरीवन रिपीट. अ कॉन्ट्रैक्ट ऑफ सेल is a contract whereby the seller transfers or agrees to transfer the property in the goods to the buyer for a price. Am I clear? Very important term. The term contract of sale is a generic term. कौन सा टर्म है ये? It's a generic term and it includes both sale as well as agreement to sell. तो अभी सेल और अग्रीमेंट टू सेल का डिफरेंस का सबसे इंपॉर्टेंट फंडा है, ध्यान से सुनना. Where can the services also be included in the definition? My dear Shreyas, Sale of Goods Act does not include services. One of the thumb rule of Sale of Goods Act. Clear, Shreyas? Teaches or agrees to teach will not come because that is a service. Great. देखो एक छोटी 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 मिस्टेक्स जो हम क्रैश कोर्स में राइट करने की कोशिश करते हैं. आई नो यू ऑल नो द फंडास, बट छोटे छोटे फिनिशिंग टच जो बोलते हैं ना, हम करेंगे. Does property in the goods means ownership of the goods? Answer is 100% yes. इधर वो प्रॉपर्टी मतलब वो ओरियन मॉल मेरा प्रॉपर्टी है, कुतुब मीनार मेरा प्रॉपर्टी है, वो वाला प्रॉपर्टी नहीं. The ownership of the goods which he is willing to sell or agrees to sell. Am I clear, Sahana? Great. ऐसे छोटे छोटे डाउट पूछते रहो ना, मजा आता है. Can we proceed? It includes both sale and agreement to sell. सर इन दोनों में डिफरेंस क्या है? एक तो सेल हो गया, एक सेल के आगे अग्रीमेंट डाल दिया, अग्रीमेंट टू सेल, वैसा है क्या? Before getting into sale and agreement to sell, let me tell you first thumb rule of the entire act. The thumb rule of the entire act says risk follows owners. Risk follows owners. Whoever is the owner should bear the loss of destruction. Any doubt with that particular statement? Thumb rule number 1 याद है? Risk follows dash, or the risk associated with the goods is always with the owner, the bakra. It could be buyer, it could be seller, depends upon whether it is a sale or an agreement to sell. Clear है? अभी ध्यान से देखते हैं. Second hand goods also included. Anything which is movable is included. Shrikanta ka question है, sir, is the second hand goods also included? Answer is yes. Great. Can we proceed? Where under a contract, the property in the goods is transferred from the seller to the buyer immediately at the time of formation of contract, it is called sale. So sale में क्या होता है? The ownership is immediately transferred to the buyer. The second thumb rule I am going to tell here. The second thumb rule says, for transfer of ownership, payment of price is immaterial. To understand whether the buyer is the owner or seller is the owner, payment of price is immaterial. It does not mean that payment of price hoga hi nahi. No. We are just trying to understand who is the owner, whether buyer or seller. To determine who is the owner, payment of price is immaterial. Am I clear? Answer nahi aa raha hai. Am I clear? Great. So in case of sale, ownership is transferred immediately, irrespective of delivery of goods, irrespective of payment of price. Delivery of goods can be done immediately, can be done later. Payment of price can be made immediately, may be made later. But if it is a sale, the ownership is immediately transferred. Any doubt? Pakka? Any doubt? No, sir, no, sir, no, sir, no, sir. Very good. But what happens in case of agreement to sell? Where in contract of sale, the transfer of property in the goods is to take place in future time, subject to some condition that to be fulfilled. Which means to say, ownership is not transferred. The ownership remains with the seller till the time certain condition to that particular contract is been fulfilled. Anushka came to me and told, sir, you are a dealer in pen, kindly manufacture 100 pens and give it to me, or this 100 pens are available with you, give it to me, but I want my name written on that pen. With best regards, Anushka. Now, can I do Jumantar? Chal beta, pen, find, control A, replace. जो हम वर्ड डॉक्यूमेंट में करते हैं ना, कंट्रोल F, find, word, replace this. Can we do it on the pen? जो पत्रकार लिए बुश पूरा क्लियर हो जाएगा? नहीं. Till the time I do it manually, replace everything or machinery, whatever way, till the time I do not print the name with the best regards Anushka on it, it remains agreement to sell. Once the conditions are fulfilled and the buyer has the notice of the same, then only the ownership is transferred. So in case of sale, ownership is transferred immediately, but in agreement to sell, ownership is agreed to be transferred in future date, subject to certain condition to be fulfilled. Any doubt? Any doubt? Any doubt? Great. So first magic box. Distinguish between sale and an agreement to sell. Expected question. Here are the answer. First distinction is based on transfer of property. The property in the goods is transferred immediately. किसमें होता है ये? Sale या agreement to sell में? Sale. The property in the goods passes to the buyer on future date on fulfillment of certain conditions. Clear है? Great. Second, burden of risk. Risk of loss is that of the buyer since risk follows ownership. किसमें होता है? Sale में. Whether the payment is made or not, delivery is made or not. Risk of loss is that of seller in case of agreement to sell. Third, remedies for breach. The seller can sue the buyer for price of the goods because the passing of property therein to the buyer. The aggrieved party can sue for damages only, not for the price, unless the price was payable at the stated date. Nature of right. Sale creates just in rem right against the entire world for the seller, for the buyer, but agreement to sell creates just in personam only against the contracting party. Right of resale in case of sale, the seller cannot resell the goods. The seller may resell the goods since the ownership is with the seller. In case of sale, the buyer can resell the goods. But in case of agreement to sell, the seller can resell the goods. Am I clear? छोटा सा 4 point difference का लिखोगे. Clear है? Sure? You can also include one-liner example. Can we move on? Essential elements of valid contract. All the requirements of valid contract like free consent, consideration, lawful object, etc. to be fulfilled. क्योंकि the term contract is given, all the 11 essential elements, if you remember with IC, Indian Contract Act. Indian Contract Act में बताया था ना? Essential elements of valid contract. Free consent of the parties, competent to contract for a lawful object with a lawful consideration and not expressly declared to be void. Offer and acceptance, mutual consent of the parties, certainty of terms, possibility of performance and legal formalities. वो सारी चीजें इसमें भी होनी चाहिए. Second, there must be minimum 2 parties. One, the buyer, and second, the seller. Any doubt in this? Third is very, very important point, which says the subject matter of contract of sale is always and always and always goods. क्या है subject matter? Goods. And how many of you remember the definition of goods? Goods under Sale of Goods Act includes dash, 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 but does not include dash and dash. याद है ना? Next, the property in the goods must be transferred to the buyer. What is the end objective of transfer of property? What is the end objective of sale? Transfer of property. Then there must be some price for the goods and it may be either expressed or implied. Does it include mortgage? Akshay Sheth, I hope you have joined late in the class. At the beginning of the class itself, it was told it does not include mortgage, neither include pledge, nor include services. At the beginning of the class itself, it was told. Did I tell that? Okay, you told it does not include mortgage. Yes, it does not include mortgage. Very good. यही होता है बेटा जब चैट करते तो interpretation of the terms becomes difficult. Sorry for interpreting it wrong. Can we proceed? Contract of sale may be absolute. What does it mean? Can anybody explain this? There is a question which has come from one of your classmates, Swati. Sir, the contract of sale may be absolute. Means what? Okay. No. Absolute का मतलब होता है without any condition. If it is with condition, it becomes what? Contingent contract. The contracts can be either absolute or contingent. याद आया? Unconditional, conditional. Unconditional is a contract and conditional is a contingent contract. समझ में आया? जब contingent contract पढ़ा था ऊपर first liner was that the contract can be either absolute or contingent. Conditional, unconditional. Great. Thank you. Can we move on? The magic box is waiting. Areva is a with a view to boost the sale, MS ABC Limited sell a new machine to Mr. B on trial basis for the period of 3 days. With a condition, if Mr. B is not satisfied with the performance of the machine, he can return back the new machine. However, the machine was destroyed in a fire accident at the place of Mr. B before the expiry of 3 days. Decide whether Mr. B is liable for the loss suffered under Sale of Goods Act 1930. So what happened? ABC Limited delivered machine to Mr. B. So delivery of goods has already happened. Mr. B has started using the machine. It was sent on 3-day trial. And before the expiry of trial period, the machine got destroyed due to fire. Is Mr. B liable because it has happened in his godown? No. Very good. No, since the agreement to sale was there, it was not a sale. Very good. B isn't liable as the ownership is not yet transferred. Mr. ABC is liable. The property in the goods would have been transferred after 3 days. Ownership is with MS ABC. Okay, let's see. I think your answers are right, but this is how it was presented. The problem as asked in the question is based on the provision of Sale of Goods Act as contained in section 8, where an agreement to sell specific goods and subsequently the goods without any fault of a part of the seller or the buyer perishes or becomes so damaged as no longer to the answer to the description in the agreement before the risk passes to the buyer. The agreement is therefore avoided. In the given case, the subject matter of the contract, that is new machine, was destroyed before the transfer of property to the seller from the seller to the buyer. Thus, the risk passes only when the ownership is transferred to the buyer. Therefore, in the present case, Mr. B is not liable for the loss suffered due to the fire accident over which B has no control. Thus, ABC Limited has to bear the loss. My dear friend, this is a very important point. If you are able to justify this point and then say because of this rule, Mr. B is not liable and MS ABC is liable, it gives more relevant and weightage of the answer. It could be just a 2-marker question, but still I would want you to focus on this, where an agreement to sell a specific goods and subsequently the goods without any fault of part of the seller or the buyer perishes or damage, and it is no longer to the answer to the description in an agreement. Before the risk passes to the buyer, the agreement is thereby avoided, becomes void. Am I clear? So based on this particular funda, Mr. B is not liable. Clear? Hai? What if B intentionally damages the goods? He will be guilty of fraud and he have to pay for it. Sir, those words are so technical. Yes, my dear friend Ronson. Whenever you are trying to correlate with the concept, there will be some technical terms, or in a layman's language, you can write where under a contract of agreement to sell, if the goods destroys, before the ownership is transferred to the buyer without any fault of buyer or seller, the contract becomes void. This is in a layman's language. Sir, in the case did not mention about Sale of Goods Act line, we can use Contract Act. My dear friend, it's about telling your answer based on which provisions. You can use Contract Act, but the more relevant would be, since it is goods, the more relevant would be Sale of Goods Act. Pawan, am I clear? Can we present in that way what I have mentioned or told? Answer is yes. As per the, you can see, you can start. As per the provision of Sale of Goods Act, when the goods perishes before the transfer of property to the buyer without any fault of buyer or seller, in such case, the contract becomes void. In exam, they will mention as per which act. No, sir. Might be, might not be. Clear? So in a layman's language, I have told you what is expected. Technical terms, I have shown you what has been written. So whichever you feel comfortable, write it. Clear? Great. Can we start? Subject matter goods. Goods includes every movable property, stocks and shares, growing crops and grasses, all types of tangible and intangible assets, and और क्या था भाई? Movable property, stocks and shares, growing crops and grasses, tangible and intangible assets, and old and rare coins. But does not include money by itself and actionable claim. Am I clear? याद है 5:2 ratio? How many of you remember 5:2 ratio? Includes dash, 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 does not include dash and dash. All movable properties, stocks and shares, growing crops and grasses. Abhi, growing crops and grasses with dhyan rakhna, which can be cut and served separately from the land. It is not along with the land. So crops and grasses, they have told, not with the land. Growing crops and grasses which can be cut and served separately from the land. All types of tangible and intangible goods and old and rare coins which are no more legal tender money. But does not include money by itself. The money by itself here means the current currency in use. It can be exchanged but cannot be sold. And actionable claim. Sir, under English law, stocks and shares are not included, but included in Sale of Goods Act. Answer is English law. I am not 100% sure, but in India, it is included. Contract of sale may be express or implied. Answer is yes, it could be either expressed or implied. You go to a shopping mall where the goods are there lying with a tag, you pick and come back. It is implied that you wanted to buy this. Sir, I know Bitcoin is illegal in India, but are they considered as goods? बेटा इंडियन लॉ में क्या बोला है? इलीगल है तो इलीगल है. It cannot happen. ये भगवान ये बहुत ज्यादा हो गया. Can we proceed? What are actionable claims? Actionable claims are not goods because such a claim can only be enforced by action in the court. Debt due from one person to another is an actionable claim and cannot be the subject matter of contract of sale. I had to receive some money from others. Can I transfer this to somebody else? Answer is no. My goods are caught at the what you call customs duty. It was imported from China. I did not pay the custom duty. It is stuck in the customs officer. Can I sell these goods now? Unless until the custom duty is paid and released by the court, these goods cannot be sold even though they are movable goods. Am I clear? Actionable claim means the person has a right to recover things by suit, but does not have the enjoyment of things. Am I clear? Whichever you can receive by filing a court's case, and after the court's judgment you receive those goods, they are called actionable claims. Clear है? एग्जाम में याद रखने के लिए दो बातें याद रखना है बेटा, actionable claim and money. And you have to write money is not goods because they are legal tender money, which is currency in use. Clear? Clear hai? Let's move on to understand types of goods. Am I going too fast? Is the pace okay for you to follow? Sure. Able to follow, right? Sir, can you repeat what is actionable claim? Beta, actionable claims means a person has a right to recover the goods, but by filing a case against it and getting it. I can recover the goods lying with the customs duty only and only after I clearing the custom duties. No doubt they are goods which are movable in nature but cannot be sold unless and until the claim has been settled. Am I clear? Actionable claim can be assigned, sir. Answer is might be, might not be. Depends upon the goods. Great. Let's move on to understand types of goods. What are the types of goods included as per Sale of Goods Act? The goods which forms the subject matter, which includes 5 and excludes 2, can be of 3 different types. Number 1, क्या है? Existing goods. Number 2, future goods. And number 3, contingent goods. Existing, future, contingent. This existing goods, as the name indicates, are in existence, which are owned and possessed by the seller at the time of formation of contract of sale. At the time the contract of sale is made, the seller has the ownership as well as the possession of the goods. Then such kind of goods are called existing goods. Am I clear? Great. This existing goods can be of 3 types. Number 1, specific. Number 2, unascertained. And number 3, ascertained. As I told the example in the class, the same example I am going to repeat. Very, very easy to remember. Clear? What happened? Nikhil came to my shop. I am a daily provision shopkeeper. Who am I? I am selling the daily needs goods. Toothpaste, brush, soap, all those things, right? Now, Nikhil came to general store. Very good. Technically right term, Shrikanta. Very good. General store merchant. Okay. I sell these goods. My first customer of the day is Nikhil. Nikhil came to me and told, sir, kindly give me 10 rupee close-up toothpaste. Case 2. Nikhil comes to me and say, kindly give me 10 rupee toothpaste. Now, 10 rupee toothpaste, I have 10 different options. क्लोजअप है, बबूल है, पेप्सोडेंट है, ब्ला 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 ब्ला, 10 different options. I give, ले ले बेटा, 10 different options. Out of the 10, I picked and gave him one. कि ले ले बेटा, Colgate, इसमें भी नमक है. And he told, yes, I am willing to take Colgate because मुझे भी नमक चाहिए. 10 rupee close-up toothpaste is a specific goods. 10 rupee toothpaste is an unascertained goods. After the formation of contract, picking one from the lot and giving it is ascertained goods. Any doubt? The goods which are identified and agreed upon by the party at the time of formation of contract of sale is specific. Which are not identified at the time of formation, unascertained. Which are identified after the formation of contract, it is ascertained. Identification of the goods, but all three are in existence. All three are in existence. When will ascertained becomes unascertained become ascertained? When they are identified and agreed upon by the parties. Am I clear? Great. Any doubt with specific goods? 10 rupee close up toothpaste क्या है? Specific. 10 rupee toothpaste क्या है? Unascertained. After entering into the contract, out of the 10 different varieties of toothpaste, when we pick up one and deliver to the other party on mutual consent, it is called ascertained. Clear? So I will repeat three technical terms. Number one, specific goods are those goods which are identified and agreed upon by the parties at the time of formation of contract of sale. 10 rupee close-up toothpaste. Clear? Unascertained goods are in existence but are not identified at the time of formation of contract of sale. 10 rupee toothpaste. After entering into the contract, which are and after entering into the contract, when the goods are identified, which means to say ascertained, out of the 10, picking up one and appropriated, which is given to the other person, it becomes ascertained goods. Am I clear? Any doubt? Clear hai sir, you can continue. Thank you for the permission. Please read this important note. Sir, does unascertained goods have certainty of meanings? Essentials of valid contract. My dear friend, unascertained goods are not forming a part of sale. It is an agreement to sell. This will become a sale and a contract only and only after they are identified. Suraj, am I clear? Great. After appropriation, if it does not come to the notice of the buyer, Shishir, we will take up this transfer of ownership in case of unascertained goods, ascertained goods. Sab kuch next topic mein aayega. Let me not dig into that topic. Keep your question reserved for some time. Can we proceed, Shishir? Shishir. Okay, great. So abhi ke liye itna dhyan rakho beta. In case of existing goods, a sale can take place only and only if the goods are specific. For unascertained goods, they can only become an agreement to sell unless the goods are ascertained, and the unascertained goods cannot be transferred. Once they are ascertained, then it becomes sale. Till the time they are unascertained, they are agreement to sell. Any doubt? Great. Future goods. Future goods are those goods which are not in existence with the seller. These goods may be either manufactured or acquired by the seller after making of contract of sale. So if you don't have it, you cannot sell it. Can it become a contract of sale? Can it become contract of sale? Taka tak taka tak fatafat. So sale of agreement to sell the future goods is an agreement to sell, not a sale. Am I clear? They are not in existence with the seller, which means to say वो जिंदा नहीं है या उसके पास नहीं है. He might acquire these goods from others and sell it to you, or he can manufacture those goods and then sell it to you. Am I clear? Contingent goods are also kind of future goods. The goods are there, but the performance of those goods to sell or not sell depends upon a collateral event to the contract, which may or may not happen. Contingent contract yaad hai? I will sell this if I get this. When am I liable to sell this? If I get this. So contingent goods are also kind of future goods. These are those goods, the acquisition of which is contingent upon happening or non-happening of a future uncertain event. We want an example of future goods and contingent goods. Okay. I came and told, see, I am a manufacturer of this particular mobile. You want 100 mobiles. After receiving the order, I manufacture 100 mobiles and then sell it to you. It's a future goods. It is not available with me. Now, these goods have already been dispatched from the company and it is on the way to me. I will be able to sell only and only if this goods reaches me. Now, this is a contingent goods. When am I liable to sell? If the goods reaches me. So both are kind of future goods not available with the seller at the time of formation of contract of sale. Future goods may be either manufactured or procured. Contingent goods depends upon the happening or non-happening of a future uncertain event. Am I clear? Am I clear? Great. Can we move on? While saying the types of goods, you said there are 5 types of goods. मैंने कब बोला 5 types of goods? Anushka, I did not say 5 types of goods, beta. I told goods includes. Goods includes क्या क्या है? All movable goods, stocks and stash, growing crops and grasses, all types of tangible and intangible assets, and old and rare coins, which are not a legal tender money, but does not include money by itself and actionable claims. Next, Sahana has told, is contingent goods also an agreement to sell or a contract to sell? It is an agreement to sell. Am I clear, Sahana? Great. Sir, whether Amazon, Flipkart can be an example of contingent goods? It's an example of e-contract. The most appropriate answer is e-contract. Anything you purchase from Amazon or Flipkart is an example of e-contract. Can we move on? The magic box. Write exemplary note on future goods and specific goods. Kindly read this. फ्यूचर गुड्स में भी उन्होंने दो टाइप दिए हैं. In case of future unascertained goods, property will be transferred after they are ascertained. In case of future unascertained goods, by description, property to the buyer when this description in the deliverable states are unconditionally appropriated to the contract. On the other hand, specific goods means to say goods identified at the time of contract of sale. So please make a note of it. It might be your 2-mark question, or at times ICI might be very much happy with you and might ask the same question for 4 marks. Clear? Great. Now what happens if the goods are destroyed? Destruction. When the goods are destroyed before the formation of contract, who was the owner? Who was the owner when the goods have been destroyed before the formation of contract? Seller. Who will bear the loss? Seller. Will the contract come into the picture? Will the contract come into the picture? No. Superb. What a part of goods is perished before making the contract? The part is perished, part is not yet perished. The rules say if the goods are divisible in nature, the contract can be enforced to the part. If the goods are indivisible in nature, the contract becomes void. It depends upon whether divisible or indivisible. Now, example of divisible and indivisible. I ordered for say 100 Ganesha idols. 5 of them are destroyed. Balance 95 can be executed. I ordered for 1 Ganesha and the trunk of the Ganesha is broken. Is it divisible? Can I get a Ganesha without a trunk? It completely becomes void. Am I clear? When the goods perish after agreement to sell before sale. Whenever the goods are perished after agreement to sell, but before sale. So where is the time gap in which it is perished before it becomes the property of the buyer? Who should be liable? Seller. भैया depends upon the property. कौन है वो? मारूंगा. Depends upon the property. अरे बाबा seller के पास गया ही नहीं है. Before going to the sorry buyer के पास गया ही नहीं है. Before going to the buyer. Before sale, मतलब ownership is not transferred. Who remains the owner? Seller. Am I clear? But इधर एक important point समझना बेटा. Where in the contract of sale of specific goods, the contract is void if subsequently the goods have perished and there is no fault of the party of the buyer on the part of the buyer or seller in perishing of the goods. But it does not apply in case of unascertained goods. If unascertained goods are destroyed, contract will not become void. ध्यान से सुनना example. Nikhil to okay, Ganesha example to be repeated. I will repeat after this statement. My dear friend, please understand. Nikhil came to me and told 10 rupee toothpaste. Was it a specific good, unascertained good, ascertained goods? Nikhil's statement was kindly give me 10 rupee toothpaste. Unascertained. I went inside. I had 10 varieties, but Colgate is already been pasted by the rats. Now that Colgate has been destroyed. Can I say contract comes to an end? अगर कॉलगेट खराब हो गया तो पेप्सोडेंट बेचो, पेप्सोडेंट खराब हो गया तो बबूल बेचो, बबूल खराब हो गया तो डाबर बेचो. Yes or no? So when the goods are perished after agreement to sell and before sale and they are unascertained in nature, contract will not become void. Am I clear? But they are specific in nature. Contract will become void. Clear? Somebody asked me, sir, can you repeat the Ganesha's example? It was with related to destruction of goods if it is divisible, indivisible. I ordered 100 pieces of Ganesha's idol, out of which 5 pieces got damaged. 5 trunks were broken, but 95 were all great, good, marketable in nature. The contract can be executed to an extent of 95. But I have ordered only one Ganesha and the trunk is broken. Can I divide this now? Without trunk Ganesha, can I sell? No. So what happens? If the goods are indivisible in nature, complete void, if they are divisible in nature, to the part they are damaged can be excluded and others can be sold. Am I clear? So what if the goods are destroyed after sale but the possession is with the seller? Buyer the bakra. Can buyer refuse the 95 Ganeshas? My dear friend Anusha, we will see in the case of wrong delivery of goods. अभी के लिए उसको hold पे रखो. Chandan Raj and Anusha. Chandan Raj, I have answered your question. Anusha, your question is put on a hold for tomorrow's class when we discuss about delivery of goods when the goods are in wrong quantity or not as per the agreement. What are the rules? Can we? Great. Anusha abhi ke liye hold pe. Destruction of future goods. If the future goods are specific, the destruction of good will amount to supervening impossibility and the contract shall be void. Sir, ये future good specific कैसे हो सकते हैं? Sir, after sale, buyer says he will not take the Ganesha in his vehicle and it is got destroyed. Then what? ए भगवान, इनको सबको है ना थर्ड टॉपिक फोर्थ टॉपिक के क्वेश्चंस की पड़ी है. Beta, please understand, default of a party not taking the delivery of the goods has to bear the loss. Clear, beta? Prasad? In case of unascertained goods perished, can the buyer claim the damage? Beta, contract becomes void, beta. Sorry, unascertained. Yes, he can claim the damages. Specific goods, contract becomes void, no damage, supervening impossibility. Unascertained goods, contract is not void and he can claim damages. Am I clear? Now, can you tell me an example of future specific goods? Old ornaments, cake, milk, क्या है ये? 10 necklaces, gold ornaments, अरे बाप रे. My dear friend, please understand, future specific goods. Kindly, okay, Mr. X entered into a contract with a farmer for buying all the mangoes growing in that particular 1 acre of land. And that land got destroyed and all the mango trees got destroyed. Contract becomes void on the ground of supervening impossibility. But if that farmer had 3-4 lands and I was not specific which particular land mango I want, then it is a future destruction of future unascertained goods. The contract will not become void. Instead of land 1, he has to supply from land 2 and land 3. Am I clear? Clear? Eh? If the goods are destroyed after sale but before delivery, अरे बाबा सेल हो गया, ध्यान से सुनो, आफ्टर सेल, buyer. Who should bear the loss? Buyer. Am I clear? Good. Any doubts? Can we proceed? Okay. Can a production of any specific type of pen be a future specific goods? My dear friend, this pen can be manufactured again. That cannot be a future specific goods. That has to be a future goods. Clear? Mode of determining the price of the fixing the price. Dear friends, again a small concept but very important concept. You might get a very important question. यहाँ पे एक पिटारा है. Eagerly waiting. Yes, no. Very good. Before going to the pitara, let's understand price. What do you mean by the price? Price is a money consideration payable for sale of goods. The price in the contract can be fixed by number one, by an agreement itself, by a contract itself. I say I want to sell at 100, you say I want to buy at 100, finish. It is agreed in an agreement and close. Number two, the price can be fixed in accordance of an agreed manner. Generally it happens in the stock markets or when you buy the gold or stuff like that, where the price at the time when you buy the gold or stocks will be the price sale price. That is an agreed manner. Number three, price can be fixed by the course of dealing. Generally this happens between wholesaler and retailer. There is a fixed MRP minus X percentage will be a price at which the products will be supplied. So by course of dealing, you understand that this is the percentage of discount I get and this will be the price. Number four, where the price is not fixed by the buyer, not fixed any of the above mentioned mode, then the buyer has to pay a reasonable price. And what is reasonable price? Matter of fact. And the last point, very, very last and important point, a price can be fixed by a third party. Look at the note. Where such a third party cannot or does not make such valuation, the contract becomes void. However, if the goods or any part of there has been delivered to the buyer, he shall pay the reasonable price thereof. Kindly read this and tell me how many of you understood this question. How many of you have understood this question? Little confusing, sir. Sir, last two lines are confusing, sir. Price he cannot ask for the second car, okay? Reasonable price for the first car, second contract can be avoided. has to pay for one car a reasonable price, but however, car cannot be transferred since contract is void. Okay, another car cannot be transferred. David had to fix the price. He did not. उसके आगे पता नहीं sir. Okay. Interesting question है. Okay. Majority of them got it right. So let me open the answer. Conclusion देखो. Regarding the car already delivered, Angel cannot ask for return and must accept a reasonable price. As regard to the second car, Peter cannot insist on its delivery to him since the contract has become void. Sir, can you explain the question once? Very good. Kaun tha bhai? Rupa. Okay. Rupa, what happened? I and you enter into the contract. I told I am willing to sell my both the cars. And the price has to be fixed by, say, Ronson. And I delivered one of the car to you. Ronson came. I told Bhaiya price fix kar le. I have to deliver the other car also to Rupa. And Rupa also has to make the payment for the both. Ronson remained silent. Now, since Ronson remained silent, the price was to be fixed by the third party. And third party to the contract remains silent. General rule is contract is void. But in case if the goods have already been delivered, for those goods, a reasonable price has to be paid by the buyer. But if the goods are not delivered, it will become void. In our given case, one of the car was delivered and hence a reasonable price has to be paid by the buyer. But the second car was not delivered. He cannot insist on delivery of that car because the agreement has become void. Am I clear? Rupa? Great. My dear friend, one more important note you have to make it. If a third party is stopped by fixing a price, I and Rupa entered into the contract. Rupa went to Ronson and said, Sun, price fix kiya na? Panch milega. And Ronson remained silent. Who has to suffer the loss? I can claim money from Rupa. Clear? अभी एक छोटे मोटे concepts है और concepts clear. Very good. What is the difference between sale and agreement to sell? In case of sale, ownership is passed, buyer becomes the owner. What is a bailment? How many of you know the difference between bailment and sale? Fatafat. Again. Sir, can Angel ask for the car again as the possession is with her? Answer is no. Once the delivery is made, a reasonable price has to be paid. In case of price is to be fixed by the third party. ध्यान से सुनना. In case of bailment, the possession of goods is transferred, nor the ownership. In case of bailment, the bailee has to return back the goods as soon as the purpose for which it was delivered has got fulfilled. The contract of bailment may be gratuitous, may not be gratuitous. What do you mean by this? It may be free also. But can there be a free sale? No. Example, when you deliver your cloth to a tailor, when you leave your vehicle for a service at a service center, you transfer the possession but not the ownership. As soon as the cloth is converted into shirt or the service has been done for a two-wheeler, it has to be returned back. Yes or no? The person holding the possession will be treated as bailee, holder of the goods but not the owner of the goods. Am I clear? There might be consideration in bailment, there might not be consideration in the bailment. Assuming you have gone for a service, he has done the service. After 4 or 5 days, there is some small problem with your brake. You go there, he adjusts that brake. Do you make the payment for that? Answer is no. So it is a gratuitous or non-gratuitous act. Am I clear? Great. Hire purchase. How many of you know what is hire purchase? My dear friend, let's first read this difference so that we understand what is hire purchase and then we understand how to take it forward. इतना बड़ा difference डाला अरे बाप रे. And beta, don't be worried, it will be your 8-mark question. Time of passing of property. Property in the goods is transferred to the buyer immediately. The property in the goods passes to the hirer only upon the payment of last installment. Position of the party. The position of the buyer is that of the owner. The position of the hirer is that of a bailee, and he till the time he pays the last installment. Termination of a contract. The buyer cannot terminate the contract and is bound to pay the price. The hirer may, if so likes, terminate the contract by returning the goods to the owner without any liability to pay remaining installments. Burden of risk of insolvency of the buyer. The seller takes the risk of the losses resulting from the insolvency of the buyer. The owner takes no such risk for the hirer fails to pay the installment. The owner has a right to take back the goods. Transfer of title. The buyer can pass a good title to the bona fide purchaser. The hirer cannot pass the good title to the bona fide purchaser. The buyer may resell the goods. The hire purchasers cannot resell the goods unless until the last installment is paid. समझ में आया? Guys, come on, answer. What is bona fide buyer? The buyer who acts in a good faith without knowing that he is not the owner to sell. Example for hire purchase, you getting a two-wheeler on a loan. The banker, you pay every month installment. Vinisha? Why it is told as an hire purchase is a combination of agreement to sell and the bailment. Okay. It is an agreement to sell because the ownership is not transferred. It is a bailment because the possession of the goods is available with the person who is the hirer. Am I clear, Vaishnavi? Hire purchase is a combination of agreement to sell and a bailment. What, sir, what is the seller's takes risk in insolvency in the burden of risk? My dear friend, you have sold the goods to the buyer, and buyer has become insolvent. You are taking that risk. Can you claim back the goods? Answer is no, the ownership is already transferred. But in case of hire purchase, the ownership is not transferred. You can anytime get back your goods. Am I clear? Can I close this? Sir, in the point of termination of contract during sale by seller, if the time is assigned to contract, then what happens? It has to be performed within the time. Sir, in hire only possession is transferred. No, sir. Answer is yes. Rented home is an example of hire purchase. Answer is no. Because you will keep on paying the rent. Where is the last rent when you pay and purchase this house? You cannot purchase this house, right? Varshini, the ownership will never be transferred to you. Home loan, yes. Sir, is a lease an example of bailment? Lease could be an example of bailment, yes. Can we proceed? Vehicle loan, yes. Contract of work and labor. In a contract of work and labor, the substance of the contract is exercise of skill and labor, and delivery of good is only subsidiary. What happens? Diwali aa gaya. Chunna chunna, chunna chunna. You have to put all your white walls into beautifully decorated white walls. So what do? You hire a person. Paint karna, right? Chunna chunna. Okay. You hire a person, supply him goods. कि ले बेटा 10 किलो चुना, 10 किलो सीमेंट, 10 किलो ये, 10 किलो वो, पेंट ब्रश वगैरह सब कुछ, and he paints. Is it a contract of sale? You have supplied goods, yeah. You have supplied paint, you have supplied putties, you have supplied brush. No, it's a contract of work and labor, wherein you have supplied goods, which is a subsidiary for him, or I could say collateral for him to complete the task. Am I clear? Contract of work and labor is not a contract of sale. That is why we are say beta, it does not cover under Sale of Goods Act. Sir, lease after a certain period you have to return the goods. How is it hire purchase? I said it is a bailment. I never said it is a hire purchase. Arjun, the question was, is lease a bailment? Answer is yes. Is lease a hire purchase? Answer is no. Clear, Arjun? Reply, dear. Great. Again, case-based study. Case का एक हो जाना भाई बड़ा क्यों टेंशन दे रहा. Comment on the following based on the legal provisions. Mr. A purchased a refrigerator from Mr. B on hire purchase agreement expiring on 31/12/2015. Mr. A sold on 1/5/2013 the refrigerator to C, who purchased against adequate consideration. A has to give a good title to Mr. C. Is rented out also a bailment, sir? A kind of bailment. Now, how many of you comment on the following? If C has acted in a good faith, C will not get a better title because A does not have the title itself. Under hire purchase agreement, ownership passes to the buyer only on the payment of the last installment. The hirer under this hire purchase system has no title to the refrigerator. A cannot give a better title to C because Mr. C does not get a better title than what Mr. A himself had. No one can pass a better title than what he himself has. Nemo, det, quad, non, habit. Yes, you got it right, Suraj. If you are not the owner, you cannot transfer the ownership. Clear? Can see claim losses? Obviously, yes. ये क्या है? ओ बैंक. इसका आंसर कोई दे सकता है? Can anybody give answer to this? Okay. How many marks, sir? Very good. छोड़ो बेटा, कोई बात नहीं, मैं समझ गया तुम लोगों की देने की इच्छा नहीं है. Can we proceed? According to section 404 error. Very good. Destruction of subject matter, contract becomes void. Wow. Good. Let's move on to the last topic before we take a break. Document of title. Document of a title is a proof of possession or control of goods, which authorizes a possessor of a document to transfer or receive the goods thereof. What do you mean by this? It is a proof of possession. What is it? Proof of possession. A person having the possession of the goods gives the documentary evidence that I have the possession and I will transfer this possession to anybody else as per the instruction of the owner. This kind of document of goods includes bill of lading. Who issues bill of lading? Who issues bill of lading? Captain of the ship. Dock warrant statement. Who issues dock warrant statement? Port authority. Wharfinger certificate. Who is that war certificate? Who issues wharfinger certificate? Warehouse keeper. Railway receipt कौन देता है? Railways. Delivery order कौन देता है? Yes. Delivery order कौन देता है? The seller of the goods. Not the transport beta. The seller of the goods gives the delivery order. And airway bills are given by airway authorities. So these are the document of title. My dear friends, it's 9:25. Let's catch up at 9:30. Let's take 9:31. Okay, 9:26 okay. 9:31 ko we will be back. Please take a small quick break. Come back with a lot of energy. We have a small concept called conditions and warranties to be completed. Okay, before that, again a question has come. So what is the difference between document of title and document showing title? Document of title is a document showing possession. Document showing title is a document which talks about ownership. Examples, share certificate. Clear? Let's take a break. Join me back in 5 minutes.
was lucky. I found what I loved to do early in life. Woz and I started Apple in my parents' garage when I was 20. We worked hard, and in 10 years, Apple had grown from just the two of us in a garage into a $2 billion company with over 4,000 employees. We just released our finest creation, the Macintosh, a year earlier, and I just turned 30. And then I got fired. How can you get fired from a company you started? What had been the focus of my entire adult life was gone, and it was devastating. I really didn't know what to do for a few months. I felt that I'd let the previous generation of entrepreneurs down. I was a very public failure, and I even thought about running away from the valley. But something slowly began to dawn on me. I still loved what I did.
We are going to make it or break it based on whether we can provide products to higher education and services and relationships to higher education that thinking about that. And if we can't do that, then we ought to go broke.
And so I decided to start over. I didn't see it then, but it turned out that getting fired from Apple was the best thing that could have ever happened to me. The heaviness of being successful was replaced by the lightness of being a beginner again, less sure about everything. It freed me to enter one of the most creative periods of my life. During the next 5 years, I started a company named Next, another company named Pixar, and fell in love with an amazing woman who would become my wife. I'm pretty sure none of this would have happened if I hadn't been fired from Apple. It was awful tasting medicine, but I guess the patient needed it. Sometimes life's going to hit you in the head with a brick. Don't lose faith. I'm convinced that the only thing that kept me going was that I loved what I did. You've got to find what you love, and that is as true for work as it is for your lovers. Your work is going to fill a large part of your life, and the only way to be truly satisfied is to do what you believe is great work. And the only way to do great work is to love what you do. If you haven't found it yet, keep looking and don't settle. So keep looking, don't settle.
Yes, dear friends, welcome back. How many of you want to watch a movie? Today we have not started with a movie. Are you ready? Let me start a movie on special contract called Quasi contract. Very important from your examination point of view. A 12-minute movie. How many of you are willing to? Sure. Chalo. Is the screen audible? Are you able to see the screen? Gauri ma'am, is the screen visible?
Yes, sir, it is.
Is it audible to the other end?
Not audible, sir. It's only visible now.
Okay, let me just stop sharing. Now, ma'am?
Now let us understand the various types of special contracts. Firstly, let's find out what a contingent contract is. A contingent contract is a kind of contract where performance depends on the occurrence or non-occurrence of an event. It is a conditional contract which cannot be enforced by the law until the event takes place. If the event becomes impossible, then such a contract is termed void. For example, suppose Amar offers to sell his house to Akbar if Anthony, to whom the house has initially been offered, seems unwilling to buy. In this case, the contract between Amar and Akbar cannot be enforced by law until Anthony refuses to buy the house. However, if Anthony in the end agrees to buy the house, the contract between Amar and Akbar becomes void. The essential elements of a valid contingent contract are: 1. It must satisfy all the essential conditions of a valid contract. 2. The performance of the contingent contract must depend upon the happening or non-happening of certain future events. 3. The event must be an uncertain one. And 4. The event must be a collateral to the contract. A collateral event, however, is independent of the contract and does not form part of any consideration to it. Let's learn about few rules regarding the enforcement of a contingent contract. The first rule is contract contingent on an event happening. Let's say Rahul is willing to pay Rs 500 to Rajiv if it rains today. In this case, the contract between both can be enforced on the happening of an event, which in this case is that it rains. The second is contracts contingent on an event not happening. Suppose Madan promises to pay Rs 500 to Basant if it does not rain today. In this case, the contract between both can be enforced only if the event does not happen, which in this case is that it does not rain. The third is contracts contingent on the future conduct of a third person. Suppose Raj agrees to pay Amar a sum of money if Amar marries Parvati. But Parvati at a later date marries Shiv. The marriage of Amar to Parvati must now be considered as impossible, and hence the contract between Raj and Amar becomes void. The fourth is contracts contingent on the happening of an event within a fixed time. For example, suppose Arjun promises to pay a sum of Rs 15,000 to Bhim if a certain ship does not return within a year. The contract may be enforced if the ship does not return within a year or is sunk or burnt within a year. The fifth is contracts contingent on impossible events. As impossible events becomes void, we now come to what is termed as quasi-contract. Quasi-contract is one which is not founded on actual promises but which is imposed on the parties by the court in order to avoid injustice of any sort. It is known as an implied contract or a contract by law. It is based upon the principle that no one should grow rich at the expense of another person. In English law, quasi-contracts are also known as constructive contracts. Suppose Shiva mistakenly gives some money to Ganesh, which is actually due to Parvati. In a quasi-contract, Ganesh must refund the money to Shiva. Let us now see what the features of a quasi-contract are. 1. It is imposed by the law and does not arise from any agreement. 2. the basis of such a contract lies in the duty of the parties and not in the promise of the parties. 3. Rights under this contract are available against specific persons and not against the world. And 4. A suit for a breach of a quasi-contract may be filled in the same way as in the case of a general contract. Some circumstances relevant to a quasi-contract are: 1. Claims for necessaries supplied. 2. Reimbursement of a person paying money due to another. 3. Obligation of a person enjoying the benefit of a non-gratuitous act. 4. Finding of goods. And 5. Money paid by mistake or under coercion. Let's learn a little about each of these circumstances. Claims for necessaries supplied. When a person supplies goods to another person who is incapable of entering into a contract or who is legally dependent on another person, then the person who supplied the necessaries suitable to his condition in life is entitled to recover the price from the property of the incapable person. Reimbursement of a person paying money due to another. A person who is interested in the payment of money which another person is bound to pay by law and who therefore pays it is entitled to be reimbursed by the other. However, there are a few conditions prerequisite for the recovery of the payment. 1. The person making the payment must be interested in paying the amount. 2. The person making the payment must not be legally bound to pay the amount. 3. The other person must be legally bound to make the payment. And 4. The payment must not be made to oneself. That is, it must be made to a third party. Obligation of a person enjoying the benefit of a non-gratuitous act. When a person performs a lawful act without the intention of getting a reward or another person enjoys the benefit of that act, then the benefiting person must reward the other person. However, there are a few rules for the payment of a reward. 1. The thing delivered or the act done must be lawful. 2. The act should have been done without the intention to claim the reward. And 3. The party for whom the act was done should have enjoyed the benefit of the act. For example, suppose Raj saves Karan's property from fire. Karan is liable to reward Raj for his act. Please note, however, that if circumstances show that Raj intended to act gratuitously and save the property, then he is not entitled to a reward from Karan. Finding of goods. A person who finds goods belonging to another and takes them into his custody is subject to the same responsibilities of having possession of the property under bail and cannot use it for his own purposes. There are a few rights and duties pertaining to the finder. 1. To take reasonable care and not to make personal use of the goods. 2. To search for and return the goods to the true owner. And 3. To recover expenses as well as reward from the owner. The finder, however, can retain the goods in these cases. 1. Where the owner cannot be found with reasonable diligence. 2. Where the owner can be found but he refuses to pay lawful charges. And 3. Where lawful charges amount to 2/3 of the value of the goods. Money paid by mistake or under coercion. A person to whom money has to be paid or to whom anything has been delivered by mistake or under coercion must repay or return the money. For example, suppose John and Philip jointly owe rupees 100 to Anthony. Both of them pay rupees 100 each to Anthony without the other's knowledge. Now Anthony is bound to repay the extra amount received from them. Let us now move on to wagering agreements. A wagering agreement is an agreement under which money or the money's worth is payable by one person to another on the happening or non-happening of a future uncertain event. A wager is a game of chance in which winning or losing wholly depends on a specified uncertain event. It is similar to a game of betting. For example, suppose David says that Yokozuna would win the wrestling match today. And if that does not happen, he would pay his friend Peter rupees 10,000. Peter in turn says yes, that if Yokozuna won, he would pay David rupees 10,000. This is a wagering agreement. These are the essential elements of a wagering agreement. 1. There should be a promise to pay money or the money's worth. 2. The promise must depend on the happening or non-happening of an event. 3. The probability of a person to either win or lose should be the same. 4. Neither party should have control over the event. And 5. Neither party should have any other interest in the happening of the event other than the sum or stake he will win or lose. These are the transactions regarded as non-wager, though they are dependent on future uncertain events. 1. The transactions for sale and purchase of stocks and shares with a clear intention to give or take delivery are not wagers. But if the intention of the parties is to settle the price difference, it is a wager and hence void. 2. Price competitions, which are a game of skill, are valid. 3. An agreement to contribute a sum of rupees 500 or above to the winner of a horse race is a valid agreement. 4. Contracts of insurance. These are the effects of a wagering agreement. 1. Wagering agreements are void. 2. No suit can be filed to recover the amount won on any wager agreement. 3. Transactions which are collateral to wagering are valid and can be recovered by the party owing the collateral. Please note, however, that wagering agreements have been declared illegal in the states of Maharashtra and Gujarat.
Yes. How was it? मजा आया? Few important points, the recalling points, and 10 minutes में contingent, wager and quasi got over. कितना अच्छा होता ना अगर ये सब कुछ ऐसे टक 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 खत्म हो जाता. Awesome recap of what we learned. Good. If you enjoy it, my day is done. Just in 12 minutes, full unit completed. All the special contracts got over. Yeah. यही तो फंडा है मूवीज का. करेक्ट. जन्म से मरण तक 3 घंटे में खत्म. Wow. So let's not get deviated. This should be how I remember in my examination. Yes. My dear friends, अगर आप चाहते हो और ऐसे वीडियोस देखें तो टाइम पे लॉग इन करो। कल 8 बजे शार्प और एक वीडियो प्ले करने वाला हूँ सेल ऑफ गुड्स एक्ट पे। ज्वाइन करोगे 8 बजे शार्प। And the students who missed the doubt clearing session yesterday, they have missed one of the videos. Beautiful video. And the students who started but quit in between also missed something. Very bad, sir. आप इतने बुरे क्यों हो, sir? Yes, I am like that. Great. Chalo guys, let's move on to is the screen visible? Great. Gayatri, please switch off your video. Great. What is a condition? What is a warranty? Magic box is visible, sir. Very good. दो magic box दिखाई दे रहा है. Should we jump into the magic box or let us start with something and then move into magic box? Let's start. Okay. My dear friends, please understand this important concept. Conditions and warranty. What do you mean by the term condition? What do you mean by the term warranty? When can a condition be treated as a warranty? And a superb concept called Doctrine of caveat emptor. This is what we are going to learn in next 40 minutes available with us. And taka tak फटाफट खत्म करते हैं. Can we? Great. My dear friend, whenever you go to buy certain goods, you go to the seller, tell him your requirement. Okay, I want this blah 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 blah. He says, why don't you take this blah 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 advantages, blah 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 disadvantages. And he will try to always convince you with the goods which he really wants to sell. Practical life में वही होता है. But still lot of communication between the buyer and seller happens before the actual sale take place. There might be some relevant conversation, there might be some irrelevant conversation which happens, but those conversation which forms a part of a contract are technically termed as stipulations. What are they called as? Stipulations. These stipulations can be either conditions or warranties. Now, what is a condition? What is a warranty? Condition are such important stipulations which forms the essence or the main purpose of the contract, and breach of which gives two rights. Number one, right to put an end to the contract, and number two, claim damages. But breach of warranty gives only one right. They are not the main purpose. They are collateral to the main contract. Breach of warranty can give only to claim damages, but cannot put an end to the contract. Clear hai? Condition kya hai? Warranty kya hai? So what could be a condition? What could be a warranty? Depends upon contract to contract. There are no standard parameters stating that what should be the condition, what should be the warranty. The funda here you have to remember is those stipulation which forms the main purpose of the contract becomes condition. Those are not the main purpose but collateral to the main purpose becomes warranty. In condition, two rights are available: put an end to the contract as well as claim damages. In warranty, only one right, that is to claim damage, but you cannot put an end to the contract. Any doubt? Great. The first magic pitara defines stipulation under Sale of Goods Act 1913. Please read this. At the time of selling the goods, a seller usually makes certain statement or representation with a view to induce the intending buyer to purchase the goods. Such representations are generally about the nature and quality of goods and about its fitness for the buyer's purpose. A representation which forms a contract of sale and affects the contract is called stipulations. Can you give an example of stipulation? Okay, Nikhil. Nikhil, you came to me and told, dear sir, I want a mobile phone which should have a long lasting battery life. I told, why don't you take Nokia? Nokia has a long lasting battery life, but it does not have a good touch and feel itna maja nahi aayega. And I wanted to sell Samsung to you. Dekh beta, Samsung le le, battery life theek hai yaar, आधा घंटा charge kar lena, ye kar lena. I'm trying to convince you for this, but you are wanting that. End of the day, what you want, I give you. All this conversation, what we had are called stipulations. Clear, Nikhil? Great. Now, which forms condition and which forms warranty? All those stipulations which are main purpose of the contract or conditions. Now, Nikhil came to me and told, I want a long lasting battery life mobile. I gave him Nokia. Nokia had an amazing battery life. That is his main purpose. But what happened? His screen was not working well. That type pad, what you call this pad where you type the message, right? That were not working fine. They are all warranties. In case of breach of warranty, it can be replaced. Keypad, okay. But if the battery itself is not working, charge dala, nikala battery out, then that's a breach of condition. But keypad is a breach of warranty. Samajh mein aaya? So in case of keypad not working fine, you can claim damages, replace it. But if condition, the battery is not working, you can put an end to the contract and also claim damages. Clear, eh, Nikhil? Great. Second question. Explain the distinctions between condition and warranty. Very important. This is a 2-mark question. Patafat dekh lo. Meaning the condition is an essential and main part of the contract. Warranty is collateral. Right, in case of breach, the aggrieved party can repudiate the contract and claim damages, or both. The aggrieved party can only claim damages. Conversation of stipulation. A breach of condition may be treated as breach of warranty, but breach of warranty cannot be treated as breach of condition. So these are the breach of condition and breach of warranty. आगे पढ़ेंगे हम लोग. When can a breach of condition be treated as breach of warranty, and when can breach of warranty be treated as breach of condition? The stipulation of condition might be treated as warranty, but the stipulation as to warranty cannot be treated as breach of condition. That is what the third point trying to say. Prithvi, am I clear? Great. Now, these conditions and warranties can be either expressed or implied. Let us take one by one. Taka tak khatam karte hain. Number 1, implied condition as to title. If you remember the case law which we studied earlier, refrigerator, it was an agreement to sell because it was an hire purchase. Did he had a better title? So what do you mean by the last difference? Can you please give an example? Okay, my dear friend, please understand. Shreyas was wanting, sir, can you give an example of stipulation as to condition be treated as warranty, but warranty cannot be treated as condition? Shreyas, hold on for 15 minutes. It will come in the later part. That time you will get your clarity. Hold on for 15 minutes. It will be answered right away. Clear, Shreyas? Great. Now, condition as to title. Whenever you are selling the goods, you should be the owner of the goods. If you are not the owner, you cannot pass the better title to the other person. It is very simple. If your title is defective, the buyer's title will also be defective. So that is the first condition which law has implied to the seller, that you should be the owner of the goods to transfer the ownership to the other party. Am I clear? The second condition as to description. Whenever the person sells the goods, he describes about the product. देखो सर ये सुपर पेन है, पूरा ब्लू कलर दिखता है लेकिन ब्लैक कलर लिखता है. एक बार लिखते रहोगे तो आप लिखते रह जाओगे, सर इसका इंक तो कम से कम 500 पेज चलेगा. He has described the product, and as soon as you got that blue color pen, it started writing in red. Is this fulfilling the condition? The description what he has told? In that case, you can put an end to the contract. Number 3, condition as to quality and fitness. अभी ध्यान से सुनना. I had no exposure to cars. I do not know what the cars are. My owner told me, Maipal, since you are the best employee of the year, go and purchase the car of your kind because you might need to travel 100 kilometers per day. I told, wow, boss ने bonus दिया, मजा आ गया. I went to the car showroom and told, my dear car showroom, please give me a superb duper car. It should be most relaxing and I should have a comfortable journey. He asked me, sir, what is the purpose of the car? I told, I have to travel every day 100 kilometers for the purpose of collection. मुझे छोटी छोटी गलियों में जाना होता है. All those things. He told, sir, the most comfortable and small chota chua if you want to take, it's the most superb car, comfortable car, take Tata Nano. I told, wow, मजा आ गया, इतनी सी कार कहीं पे भी घुस सकती है. But is it comfortable for traveling 100 kilometers a day on a daily basis? The fitness of the buyer's purpose was not there. Whenever the buyer depends upon the skill of the seller and relies on his description, and if it does not suit that purpose, you can put an end to the contract. Am I clear? But if I go there and see, oh, nano, अरे यार मजा आ गया, बैठ के देखा एकदम अच्छा लग रहा था, छोटी सी कार, मस्त मजा आएगा. I told, okay, I want this nano car, and I will be having a great drive for myself. So please give me the nano car. It's a comfortable car for me, and I have purchased that car. And after that, I realized it is not comfortable. Can I put an end to the contract? Can I put an end to the contract? Answer is no, because it is a unilateral mistake. I thought it is comfortable. Did the other seller told it is comfortable car? It is a unilateral mistake and I cannot put an end to the contract. But if my purpose was told to them and I relied on that, then it will be breach of condition. Beta, did I ask him? Clear? If I have told car, asked him, beta, I want to have 100 kilometer ride and every day I want the comfortable ride. Is this car good enough for it? And he says yes. Then he's guilty of fraud or misrepresentation. Clear? Great. Condition as to merchantability. The term merchantability means there should not be any defect in the goods which renders it unfit for the sale. If I buy a watch which does not work, is it merchantable in nature? I buy a cement with a water mix, it has become rock. Can it be used as a cement? I buy a sugar with water mix has become syrup. Can I use it for the merchantable nature? Answer is no. So the purpose for which you buy should be accordingly merchantable in nature without any defect. Next, condition as to sample. Whenever I buy the goods, depending upon the sample, you showed the sample, this is what I have. The entire lot what I purchase should be as per that sample. If the bulk is not responding to the sample what has been shown, you can put an end to the contract. Look at this very important point here. The goods shall be free from any latent defects. It is to be noted that this is an implied condition applied in the case of latent defect, that those defects which cannot be discovered by ordinary inspection. In fact, such defects are discovered when the goods are put to use by an examination in the laboratories. The seller is not liable or is not liable for apparent or visible defects which can be discovered by examination. Latent defects are those hidden defects which, if the seller himself is not known, he is not liable. Whenever the goods are sold by description and sample, the condition is it should be fulfilling both. It should be as per the description mentioned and as per the sample shown. Am I clear? And the last one, condition as to wholesomeness. My dear friend, look at this beautiful example. Wholesomeness generally deals with eatables. You cannot sell the goods after expiry date. What happened? Akshay came to me. I am a daily general store merchant. He told, sir, give me fresh bread. I gave him a packet of bread. He went home and saw the bread had beautiful, except for white color, it had also green and yellow color into it. He came back and told, sir, this bread is not good. I told her, Baba, I have charged only for white color. Yellow and green is free. Go, enjoy it. Can I sell that? Is it fit for the human consumption? No, you cannot sell those things. Very important point, custom usage and trade. Whenever a product is manufactured for a particular purpose, even though the other party has not asked that purpose, and if that product does not match that purpose, you can put an end to the contract. How many of you understood this purpose, what the purpose I told? My dear friend, you go and buy a flask. What is the purpose of flask? To keep the hot things hot. Even though you have asked or not, it should keep hot things hot or cold things cold. If it does not render that particular purpose, I took a flask, put in hot coffee. After 5 minutes, it has become cold coffee. Can you put an end to the contract? Yes. But did you tell the purpose to the seller? Arey Baba, the purpose of that product itself is to keep hot thing hot. In that case, it is a breach of condition. Am I clear? Clear? Great. Next, implied warranties. The first implied warranty is to undisturbed possession. Generally, this undisturbed possession is linked with title. When can a person's possession will be disturbed? If he does not have a better title. Am I clear? If the buyer's possession has been destroyed, or sorry, not destroyed, disturbed, he can claim for damages. Number 2, implied warranty against encumbrance, which means to say, whenever you sell the goods, it should be free of loan or any charges, or it should be free from the mortgage in favor of any third person. Am I clear? And number 4, warranty to disclose the dangerous nature of goods. In the case when the dangerous nature of goods are there, while selling the acid, you should disclose the fact, beta ye acid hai, हाथ पे डालोगे तो ढूंढते रह जाओगे. Nowadays it is all written, printed. But earlier days, 1930s, there were no specification written on the goods and stuff like that. That time they told, whenever you are selling goods which could be harmful in nature while usage, the disclosure should be given. Nowadays it is everywhere printed. Smoking kills, but sorry, smoking thrills but kills. Correct? So फिर भी लोग लेते हैं. Can we proceed? When can a breach of condition be treated as breach of warranty? My dear friend, condition में कितने rights available है aggrieved party के पास? What are those 2 rights? What are those 2 rights? Put an end to the contract and claim damages. Yes or no? वारंटी में कितने राइट्स हैं? Only one right. What is that? Claim damages. Correct? My dear friend, याद रखना example which I told in the class, CW. How many of you remember? C and W. A, B, C, D, E, F, G, H, I, J, K, L, M, N, O, P, L, M, N, O, P, Q, R, S, T, U, V, W, X, Y, Z. A, B, C, D, E, F, G, H, W. Now, C can come down to W. W cannot go to C. You can always come down. It is easy. Going up is difficult. सिर्फ एग्जाम में याद रखने के लिए. You can always come down fast, but growing up in the life is very difficult. C can always become W, but W cannot become C. A breach of condition might be treated as breach of warranty, but breach of warranty will never be treated as breach of condition. Clear? What are the circumstances when condition can be treated as warranties? The buyer has waived the condition. Kal pada tha waiver, giving away your rights. I give away my rights to put an end to the contract, but still I will claim damages. Condition has been treated as warranty. The buyer may elect to treat breach of condition as breach of warranty. ठीक है यार, repair करके दे देना, चलेगा. Third, when the contract of sale is not servable and the buyer has accepted the goods. It is indivisible contract. No doubt there is a breach of condition, but he has still accepted it. ठीक है यार, जो हो गया, छोड़ना. Then condition has become warranty. When the fulfillment of condition or warranty is excused by law due to impossibility, the condition can be treated as warranty. Magic box. Describe the situation in which breach of condition to be treated as breach of warranty and all the 4 points which were mentioned. This same 4 points, but थोड़ा सा ज्ञान बढ़ा के according to section 13 blah 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 देके दिया है. Clear? छोड़ दे भाई, section number छोड़ देना. Great. The last concept of the day. अरे बाप रे, इतने सारे magic box. पक्का इधर के ही है क्या? When the fulfillment of condition or warranty is excused by law due to impossibility of law. What does it mean? When we entered into the contract, the condition was assuming, okay, ध्यान से सुनना. The condition while purchasing the goods was, I want the medicine to be packed in one single piece. Condition. But due to Corona, the medicines are hugely in demand. Law ने बोला बेटा छोड़, पूरे box में container में डाल के दे. The condition of packing single has been excused. Because of law coming into the picture, the condition has been waived off by law, by impossibility. There could be various reasons like this. So whenever the law comes into the picture, it is waived off. Very simple to remember in your examination. Clear? Great. What do you mean by the term doctrine of caveat emptor? The term doctrine of caveat emptor means to say, let the buyer be aware. He should be aware at the time of buying the goods. The seller is under no responsibility to disclose the facts unless until asked by the buyer. Am I clear? The fundamental principle of doctrine of caveat emptor say, let the buyer be aware. It's the duty of the buyer to examine the goods before he purchases. And the buyer will be not responsible for the wrong selection of the seller will not be responsible for the wrong selection of the buyer. but there are certain exceptions. And all these exceptions are nothing but breach of conditions. Goods purchased by description and if it does not match. Good purchased by sample and description and if it does not match. Goods purchased as to quality or fitness of the buyer purpose which was disclosed but did not match. The usage of trade, flask, did not match. Mercantile quality, pen which does not write, does not match. All these are exception to the rule doctrine of caveat emptor, where buyer will become responsible, not where the seller will become responsible, not the buyer. Am I clear? Taka, tak, taka, tak. So 3 magic boxes. And that will end. Explain the doctrine principle of caveat emptor. What are the exception to the rule of doctrine of caveat emptor? This was 6-mark question asked. Look at the answer. जब क्वेश्चन दिखाते हैं तब नींद लेते हो क्या? किधर डालूं यार? Okay, first read this. Explain the doctrine of caveat emptor. What are the exception to the rule of doctrine of caveat emptor? And this is the answer. Fitness, purchased under patent name, goods sold by description, mercantile quality, sample as well as description, trade and usage, and active concealment of fact deceived by fraud or misrepresentation. So these are the exception. one liner लिखना है क्योंकि 6 मार्क का क्वेश्चन है. Clear है? Sure. The next magic pitara. Oh, case based studies. मजा आएगा. Mr. Paul sold Mr. Ray certain quality of foreign refined palm oil warranted equal to sample. The sample consists of a palm oil mixed with vegetable oil. The oil trended corresponded with the sample, but it was not such as it is known in the market as a foreign refined palm oil. Mr. Ray wants to reject the oil on the ground of that the oil supplied was not in accordance with the foreign refined palm oil. Advise Mr. Ray. Can you put aside a contract? The oil was as good as the sample shown. Shraddha says yes. Shrikanta says no. Anup says breach of condition, he can't. No, he cannot. Manoj says yes, he can. Shibini says no. DP says no. Anaga says, but it should not according to the description. No, he can. He has already shown the sample and it is according to the sample. Breach of condition, he rejects the same. Yes, he can. Yes, he can. Sir, if Mr. Ray could examine these goods and find out about the mixture, then he cannot put an end. But if he cannot identify with the reasonable examination, then he can. Okay. Description did not match. It is accordance with the sample, so he cannot. Okay, छोड़ो. अभी मैं बोल देता हूँ. Question लिख लिया, बंद कर दूँ question. Mr. Ray can reject the goods. In the case of sale by sample as well as by description, goods must not only correspond to sale but also to the description. That is example, foreign refined palm oil. No amount of exemption clause can compel a person to buy a things different from the contracted to buy. I will not show you the question once again. It has been shown for so long. My dear friend, simple thing. He has described that it is a foreign palm oil and the industry standard says foreign palm oil should be of this quality. But his description did not match because it was mixed with a vegetable oil and hence he can put an end to the contract. No doubt sample was same, but description did not match. Clear? For the purpose of making uniform for the employees, the seller for the purpose. When uniform were prepared and used by the employees, the cloth was unfit. However, there was evidence that cloth was fit for caps, boots, and carriage lining. Advise Amit whether he is entitled to have remedy under Sale of Goods Act 1930. Can he claim? He did not say his purpose. Yes, he can. No, he can't. Okay, answer fatafat. He can. He can't. No, he not, because the rule let the buyer be aware applies. Okay. He did not make the purpose. So caveat emptor hence cannot. Okay. No, because it is a unilateral mistake. Cannot. Purpose of uniform is not disclosed. Very good. As per the provision, contract is an article fit for the particular purpose only arises when the purpose for which the goods are supplied is known to the seller. The buyer, relying on the skill of such judgment, and the seller deals in these goods is in the usual course of business. In this case, the cloth supplied is capable of being applied to variety of purpose. The buyer should have told the seller the specific purpose for which he is required to sell the goods. But he did not do so. Therefore, implied condition as to fitness of buyer purpose does not apply. Hence, the buyer will not succeed in getting any remedy from the seller under the Sale of Goods Act. Clear? My dear friend, tomorrow we have delivery, very small unit, sale by non-owners, types of deliveries, rules regarding delivery, time and place of delivery, wrong delivery, and the last unit of Sale of Goods Act followed by unpaid seller. So tomorrow we will be able to complete the Sale of Goods Act. Request is kindly make sure that you have studied this and come. The three important funda in this is: one, delivery of goods; second, transfer of title; and third, unpaid seller. So this is what we will be having for tomorrow. Second point, sold under patent. Patent and trademarks are generally, but if there is a defect in that, then you can put an end to the contract. Sir, can you please explain warranty as to non-existence of encumbrance? The encumbrance means to say the goods should be free from loan, advances, or any mortgage on it. I wanted to sell my car to you, but it is already pledged with someone else. So it cannot be treated as free from encumbrance. Clear? Yes, Shreyas, continue. You can ask your doubt. We have 4 minutes to go. So can you give example of unilateral mistake? Unilateral mistakes are those mistakes wherein one of the parties under the mistake in understanding the product. I thought this cloth will be used for shirts and pants, but technically it was used only for making caps. Did I tell this purpose to the other person? No. Can I put an end to the contract? No. Because it is a unilateral mistake where I am under the mistake, not the other party. Sir, even when it is dangerous goods, does the rule of caveat emptor apply? My dear friend, in case of dangerous goods, if the disclosure is not given, then it will. Sir, warranty to disclose the dangerous nature of goods is applicable to crackers? Yes, it is applicable to crackers. So that is the reason they are very, very clearly told, should be used under the guidance of the adults. They should be keep maintaining distance. Sir, in a Fair and Lovely advertisement, they mentioned that they would become fair in 7 days, but in reality, it does not happen. Can we put an end to the contract? But rescinding contract generally does not happen. Why? My dear friend, there is always a star mark put. You will become fair, provided you have followed this, which are smallly printed, which you do not know. So that is the reason company always says terms and conditions apply. Sir, can you give me an example of document to title? Document of title and document showing title are the two different terms. Document of title shows the possession. Example, railway receipt, airway receipt, etc. Document showing title is a document which shows the ownership of the goods. It could be your it could be your share certificate. It could be when you purchase your property, the transfer of property का वो जो deed paper बनता है, all those are things. So Fair and Lovely changed its name to Glow and Lovely to avoid the case. Probably yes. Sir, if the sale is made and if goods before the seller transfer his possession get burnt, should buyer pay the price for damages of the goods? Answer is yes. Sir, in ICI material, they have told goods purchased under brand name, there is no implied condition. Yes, because it is already an implied thing that it will be good and mercantile in nature. So what is the difference between executory contract and actual performance? Actual performance where you fulfill your contractual obligation, executory contract where the performance is still outstanding. Yes. How does goods purchased under patent or trademark becomes an exception to caveat emptor? My dear friend, when you purchase the goods under the patent or trademark, it is implied that this will fit for the purpose for which it is made. And if it does not fit for the purpose what it is made, you can put an end to the contract. It is based on custom, usage and trade. What is the actual meaning of provisions of law? Okay, provision का मतलब क्या होता है? As per the rules contained in the law. Can you please explain appropriation of payment? You should have come to the yesterday's class doubt clearing session. We had the poem also done. We had everything done. Now I think I don't have the time. You can call me and ask. I will explain you. Next. Sir, is mercantile quality means as per description? No. Mercantile quality means to say the purpose for which the goods are there. Voluntary waiver and compulsory waiver. Voluntary waiver when the person gives his acceptance, telling that I will not claim. Compulsory waivers can come by act of law. Clear? Thank you very much. My mobile number, you can get it from the coordinators. Thank you very much. It was nice interacting with you all. Tomorrow at 8, we will be following the class and with your doubts. And there will be one more doubt clearing session in which still all your unanswered doubts can be answered. With this, thank you very much. May God bless you. Thank you, Gauri. And tomorrow morning, 8 o'clock is the next session for me. But students, you have the next session followed at 11 o'clock. Over to you, Gauri ma'am. Thank you very much.
Yes. Thank you very much, sir, for that awesome session. Hope students will take maximum benefit of whatever you have explained. But as you said, when they come for the next class, they have to come prepared for the topic. Dear students, I think you can take a break now of half an hour. Please leave the session and come back at 11 o'clock for account, Principles and Practice of Accounting by C.A. Adarshane, sir. Thank you, sir. Thank you, dear students.
Thank you. Thank you.